The revised law of inheritance expresses itself on the order of abatement. First acquisition according to intestacy rules, then bequests, finally inter vivos gifts such as marriage and property contracts. When does that become relevant? Learn this and more in this video. My name is Tamara Freiner. I am an independent attorney at law in the canton of Zurich. If this video appeals to you, please like it and forward it to someone else. If the testator gives too much to someone, the heir entitled to a compulsory portion, who receives less than the value of the statutory share, may request a reduction, respectively an abatement. It is like shortening ponds. You take away as much as you can until it fits, or you reduce it to the permissible level. For instance, your next of kin are legally entitled to a portion of your assets upon your death and, in principle, cannot be deprived of it. What cannot be withheld is deemed to be the available quota. You can dispose of this freely. If you are survived by issue, a spouse or a registered partner, you may make a will of that part of your property which exceeds the statutory share of the survivors. If you dispose of more than the available quota, compulsory portions may be violated. Although such a will is valid, it can be contested. A heir's statutory share may also be infringed by certain inter vivos dispositions. The heir who receives less than the value of their statutory share may request an abatement of the following acquisitions and gifts until their compulsory portion becomes available. First, acquisitions according to the intestacy rules. Second, bequests. And third, inter vivos gifts. The heir may file an action in abatement, or he remains passive, waiving his right to an abatement. No plaintiff, no judge. Previously, it was controversial whether gifts subject to addition under a marital agreement are deemed to be a disposition upon death or a lifetime contribution. And in the year past, the abatement of acquisition in accordance of the law on instate succession was disputed. In the revised law, the order of reduction, respectively abatement, is specified. The following are subject to abatement in the following order until the statutory share becomes available. First, acquisitions in accordance with the intestacy rules. Second, bequests. Third, inter vivos gifts. The inter vivos gift shall be abated in the following order. First, the gift subject to addition under a marriage or property contract. Second, the freely revocable gifts and the benefits arising from a restricted pension plan, also known as a restricted retirement savings plan, in the same proportion. And then third, the other gifts, the more recent ones before the earlier ones. Allocations from marriage or property contracts are added. For instance, the allocation for which the surviving spouse or registered partner receives more than one half of the surplus in the presence of non-joint descendants. Please make a note of your legal heirs entitled to a statutory share, who they are, whether there is a prenuptial agreement, whether there will be benefits arising from a timed personal pension plan, and whether you have already made significant gifts. I look forward to supporting you fulfilling your personal and last wishes to have a peaceful distribution of your assets. Please contact me for a consultation.